Hey, everybody, welcome back to Legal Tips Live. Today, our guest is Katie Hollcraft from Northwest Justice Project. Welcome, Katie.
Hi, thank you for having me.
Awesome. Can you tell us a little bit about what your job is?
Yeah, I'm the housing intake paralegal for the King County field office at Northwest Justice Project. So that means that when clients call in, they talk to a screener first who confirms eligibility, and then they talk to me, and I gather information and give some advice under attorney supervision, and then sometimes then you may talk to attorney after that, or we sort of troubleshoot from there. With
Great.
housing specifically. That's my role.
And just to clarify, does watching this video create any sort of attorney-client relationship with you?
No, because I'm not an attorney.
Great, easy answer.
Yep, very, very straightforward.
Awesome. So today we're talking about housing and tenants' rights. And the first question is, what are the current statuses of the federal and state eviction moratoria?
Yeah. So let's start with the state one. So under the governor's current eviction moratorium for the state of Washington, you should not receive any kind of notice to vacate for non-payment of rent, or really any other kind of eviction notice for lease violation or anything like that, unless you're doing something that causes an immediate threat to health or safety of others. And there also should be no notices or enforcement of any rent increases. And that also includes any kind of verbal threat. So if the landlord, maybe they haven't given you a written, notice to pay or vacate, 14-day notice, but every time, they're calling you all the time saying that if you don't pay rent, they're going to evict you, that would also be a violation of the governor's moratorium. The other thing that's important to know about the governor's moratorium is it's much broader than just traditional tenancies that are covered by the Residential Landlord Tenant Act. So if you're staying in an Airbnb, you're living in a motel, you're staying in a campground, lots of other kinds of sort of less traditional dwelling situations, you should be covered by this. So that's something else to keep in mind. And the time frame for that, it went into effect March 23rd, and it stays in effect until June 4th. And so that's the time frame that's being worked with there. The other thing to know about the moratorium is that after June 4th, your landlord should not be starting any kind of eviction action without offering an individualized payment plan for any debt accrued between February 29th and June 4th. And they also cannot include any late fees for any of those missed rental payments. And the payment plan does need to be individualized. So if you get some kind of form letter that's going out to all tenants that says, any unpaid rent from this time period needs to be made up in $200 installments for the next however many months or something like that, that doesn't meet the requirement of the moratorium. They need to talk to you individually and figure out an individualized payment plan that they can offer based on your situation.
So that's the state moratorium, and how does that differ from the federal moratorium?
Great question. So the federal moratorium was part of the CARES Act that also went into effect earlier in March, and that covers properties that have some kind of federal subsidy or federally backed mortgage. So it's pretty easy to figure that out if you have a Section 8 voucher, if you live in some kind of public housing, anything related to Section 8 or a housing authority, that you live in a low-income tax credit building, any kind of subsidy like that. Some of them are less obvious. You might not know if your building has certain kinds of subsidies, or if your landlord has a federally backed mortgage. Sometimes your landlord might not know if they have a federally backed mortgage, if their mortgage was sold, from one company to another. So that one's harder to figure out. So if you have questions about that or you're not sure, you can ask your landlord. You can do some research. There's some resources online, including on Washington Law Help. But if you have concerns about that, you should seek legal advice. The big difference, another big difference is that the federal moratorium extends until July 24th. So you shouldn't receive a notice for non-payment of rent between now and then. You shouldn't really probably receive any other kinds of eviction notices either. Again, there shouldn't be any late fees associated with any late or delayed rent payments during that time. And when it does get to the end of that period, you should get a 30-day notice to vacate, which is probably different than the kind of notice that you'd be entitled to otherwise. So those are all things to watch out for. And again, with all of these, there's the state moratorium, there's the federal moratorium, also different cities and specific court systems and sheriff's departments have many of these different sort of systems have issued their own emergency orders and internal policies and things. And so if you're getting any sort of threat or notice of eviction or having issues with your landlord around non-payment of rent or other issues, I'd strongly encourage you to seek legal advice because it's going to be really fact specific depending on where you are, what kind of housing you're in, and what your situation is. And we'll talk about maybe those resources at the end.
Great. Awesome. So do these eviction moratoria mean that I don't need to pay rent?
No, that is not what that means. None of these laws, orders, or legislation include any kind of rent relief or rent forgiveness. So the rent is still due. You just can't be evicted if you don't pay it. And at some point there, unless you receive some other kind of rental assistance, financial assistance from a different organization, that rent is going to come due one way or another. And so the tenant attorneys that I work with and that I talk to are really encouraging people to be kind of as proactive as you can in talking to your landlord about your situation and trying to figure out a solution going forward. If you intentionally withhold rent, it's possible that, or if you reject an individualized payment plan, if it's offered, it's possible that some of these other protections and defenses that you would have would not be available to you anymore. So in order to fully take advantage of the protections that have been put in place, even though there's some questions about how exactly they're going to play out, it's really important to offer to pay rent if you can, to talk to your landlord about making either partial payments or a payment plan or something to be able to be as try to stay as safe as possible within the options that are available right now.
That's really good to know. So shifting gears a little bit, what are some reasonable accommodation requests that someone could make during COVID, and how do you go about doing that?
Yeah, so a reasonable accommodation request is a request that you make to, in this case, to a landlord for some sort of change in the provision of services, a policy, something to allow you to enjoy your dwelling the way that someone would if they didn't have the disability that you have that creates some kind of barrier. So it could be something like if your income is disability, Social Security, and you receive your payment later in the month, making a request to pay your rent after that date, so that you're able to pay on time without accruing a late fee because your income is related to your disability, or a wheelchair ramp if you have a wheelchair. So that would be a modification. That would be a physical change to the property. The key thing is being able to show to your landlord that there's a connection. We call it a nexus between your disability and the accommodation that you're requesting. And you can be creative beyond that. If there's something that you need that would allow you to live, and fully enjoy comfortably your home the way that someone without that disability would be able to. The best way to make those requests is always to do it in writing so that you have a paper trail if there's any issues down the line, and always keep a copy and make sure everything has a date on it. Your landlord, if it's not obvious to your landlord what your disability is and what the connection is between your disability and the accommodation that you've requested, your landlord can ask for some kind of verification or documentation of that disability. So if you have a care provider that you work with, a doctor or a therapist or a social worker can provide information like that. But it's not the same standard as, say, applying for Social Security. The standard of what is considered a disability under fair housing laws and the Washington Law Against Discrimination is different. So if you have a disability, that's how you identify and feel that something that you have going on, you can ask for reasonable accommodation. You don't have to have an official diagnosis. You just have to be able
Great.
to explain it to your landlord.
Great. And what are some examples of an accommodation that someone might ask for under COVID?
Yeah, so if you, something that I've seen come up is if you have some kind of disability or health condition that makes you particularly vulnerable to COVID-19 or other kinds of illnesses, if and your landlord, say, has a routine inspection that they want to make, or some kind of non-emergency repair, you could, at request that be delayed or that extra precautions be put in place. There isn't anything that I'm aware of in the law that prohibits landlords from entering units right now based on the different orders. Property management has generally been considered an essential service. But you can certainly make a reasonable accommodation request if you have a particular health concern around that. Something else might be if you normally pay your rent in person, you normally take a check into an office. You could request to pay by mail or maybe in a Dropbox or something like that to avoid contact. So again, you can really be creative, just be prepared to demonstrate that there's a connection between your disability and the request that you're making.
Great, that's really helpful. What about for folks who don't have a documented disability or illness, but just want to be extra careful during COVID? Can you ask your landlord not to enter your unit during this time?
You can ask. Landlords they are entitled to reasonably tenants are required to let landlords into a unit for kind of reasonable inspection and maintenance and things like that. And especially if there's some kind of emergent issue, if your bathtub's overflowing and water's going into your neighbor's unit, your landlord's probably going to insist on coming in. And especially if there's not that disability nexus there, as much as you can, certainly talk with your landlord, talk about the precautions that should be taken, maybe arrange for them to come at a specific time, or like you leave the door unlocked and you stay in another room, so that you're not interacting in person, things like that. But there's nothing right now that gives tenants the right to just fully deny access for any reason.
Got it. That's great to know.
Mm-hmm.
Anything else you wanted to mention that we missed?
I don't think so. I do want to make sure that everybody knows what resources are available for legal advice, because again, all of these laws are brand new, and some of them are written in ways that even attorneys aren't sure exactly how they're going to be enforced or implemented. And, their landlord's attorneys might read it one way, the tenant side attorneys might read it a different way, the attorney general may read it a different way, and then, the information that we have about the governor's intent is another factor. So a lot of this is emerging, and even if you talk to an attorney, they might say, we don't know yet. And that puts people people are just in really tough situations right now, of course, and that's going to be part of it. But I do strongly encourage, if you have a concern about any of this, something's coming up with your landlord, to reach out to different legal services. If you're outside of King County, you should call the CLEAR hotline. And I think we'll post all of this information in the comments. within King County, you should contact the Housing Justice Project or the Northwest Justice Project. But if you're in King County, you should call our front desk and we'll make sure that that number is available. And you can also always call 211, and 211 should direct you to the appropriate legal services in your area. The Northwest Justice Project also runs the Washington Law Help website, which has a lot of really good information. It's being updated weekly, daily, sometimes as different orders come down and things change. And there's a lot of up-to-date COVID-19 related information there as well that I strongly encourage people to check out.
Great. Well, thank you so much, Katie. I think this information is going to be really valuable to our community. So I'm
Yeah,
having you on today.
absolutely. Anytime. Thanks so much for having me.
Great. All right. Well, thanks everybody for tuning in. Make sure to check back next time for our next installment of Legal Tips Live. Bye.
Bye. Thanks.